Thank you very much for your precious time. My name is Sai CHEN, a Chinese attorney at law from Beijing Wei Chixue Law Firm. When mentioned China, what do you think of? Panda, Great Wall, or great deal of comedies made in China? As an IP lawyer or a manager of company's legal department, maybe you will recall some experience suffering from counterfeit. Yes, we have to admit there are some IP infringement cases take place in China, but we do have ways to seize the infringement. Today, I would like to share with you some basic information and some case as examples to introduce how to seize the IP infringement in China. First, let's see how many ways you can use to fight against infringement. Many. And all this means have their merits and demerits. You may select the proper one according to the specific situation. As for sealed letter, it is common all over the world. It has a lot of merits. It's cheap, convenient, and prompt. It can reset the statute's limitation. In China, the statute limitation is 3 years since the date the right owner know or shall know the infringement. And it can also be the evidence to prove the bad faith of the infringer. If the infringer received the sealed letter but continue to conduct the infringement activities, it is obviously in bad faith. It also has a lot of demerits. It may be ignored. According to our experience, about 50% of the case, the sealed letters are just ignored. We cannot receive any reply. And also, non-infringement lawsuit may be filed by the infringer who received the letter. Also, the unfair competition lawsuit may be filed, especially if the letter is sent to the distributor or customers. The duty of care are higher. So we advise, maybe the sealed letter shall be sent after the evidence preservation and after you confirm the infringement. The second way is publication to customers. The following contents can be included in such publication: invoice rights, the number, the statute, the authorized distributors, how to buy the genuine goods, the policy of IPR of the right holder, and such application can be released through internet, the homepage, and also the newspaper or others. The merits of such means is it can put pressures on the infringers and increase the awareness to customers. It can also appeal right holders' policy and gain support. The demerits is it cannot solve the problem directly, and there is a risk it may be sued for unfair competition, especially if you mention some name of the infringer in the publication. Link shutdown request is a way against online infringement. It means the right holders may request the platform to shut down the infringing links. The merits are it may shut down links promptly and effectively, and it can also be the evidence to prove the bad faith of the infringer if the infringer continue to sell the products. And the demerits is the platform may not shut down links if infringement is not so obviously. For example, if the case is concerning invention infringement, the platform will say, "Oh, I do not have the ability to judge whether it constitutes infringement, so I cannot shut down." And another demerit is the infringer may set up links again. Usually we advise such means can be used against the obvious trademark infringement or copyright infringement, and if the case is concerning the patent infringement, maybe you can first file the litigation or the administrative action, and when you have the judgment, you can request the platform to shut down. Then custom action. It is obviously against infringement export and import. In China, there are two types of custom action, ex officio and by application. But most cases are ex officio because if the case is by application, the right holders shall report to the customs the accurate information, including when, where, who, what. The number of the custom clearance sheet. In fact, it is very difficult for right holder to have such accurate information about the infringement. So we can use the ex officio action. First, you shall record the IP right in China custom system. Then the custom officials will notify the right holder or its attorney if they find some suspected goods when checking the goods. When the right holder receives the notification from custom, it shall give the reply within 3 days. If they think the goods are genuine goods, they can request custom to release, and if they think it's infringing goods, it may request custom to detain and pay the guarantee. The merits is it can seize export or import of infringing goods promptly and effectively. The demerits is the customs may not find all the infringement goods and usually only notifies obvious infringing goods. As you know, there are thousands, millions of goods import and export every day. So the custom cannot check all the goods. They will random inspection the goods, and the rate of inspection will be lower than 3%. So they cannot find all the infringement goods. Then the administrative action. It is unique in China. That is, you can request competent organizations. For example, if the case is about trademark infringement or the patent infringement, you can report to the Administration for Market Regulation to deal with the infringement dispute. The merits is the actions are rapid. Usually, if the case is about some trademark infringement, the organizations, officials will investigate the sport and determine whether it constitutes infringement within 1 month. And if the case is about patent infringement, the officials of the organizations may issue the decision about whether it constitutes infringement within 3 months or 4 months. The demerits of such means is compensation for damage cannot be requested, and the administrative organization is not so powerful, and for some complicated cases, it cannot be dealt smoothly. The final ways is litigation. The merits is compensation for damages can be requested, and it can shut down the infringing activity firmly and effectively. Also, it has advantages on handling complicated cases. The demerits is it is difficult to collect all the evidence. In China, the burden of proof of the plaintiff is very high, and its cost and time wasting. It will cost a lot than above mentioned other means. Then I will introduce some cases to give you some impression of how to seize infringement. And all the cases mentioned are handled by our firm. The first case is a design patent infringement cases. The right holder is the famous Japanese company Panasonic. The product is Chimmer, very popular in China. And the infringing products are sold all over the internet, the Taobao, Alibaba, and Jingdong. So the Panasonic want to cease infringement, but considering the price of the products is not so high, just maybe 500 Chinese yuan for one product. So they think they cannot get a lot of compensation through litigation in China. They will not cost much, but just obtain nothing. So they do not want to file litigation. At first, we do not file the litigation. We request the platform to shut down the links. But the infringer continued to set up the new links, and it also has their own design patent registered. They give their own design patent registered certification to the platform, and it makes more difficult for us to shut down all the links. Then we have no other choice. We filed the litigation in 2015. The first instance judgment was issued in the end of the year, and the second instance judgment take effect in the next year, in the December 2016. And this judgment confirmed the infringement and determined 3 million Chinese yuan compensation. At that time, it's the highest compensation determined by court in the design patent infringement cases. And this case has also been selected as top 10 China IP protection litigation cases in 2016. After the litigation, the infringer continued the infringement. It still sells the invention until the May 2017, and they also slightly modified the products from the March 2016. So we filed a second litigation in 2017, and because of the pressure of the litigation, the infringers ceased infringement in 2018, and the second instance judgment was made in 2021. This judgment confirms the infringement, including the old one and the new one, and also determined more than 4 million Chinese yuan compensation. Through this case, not only Panasonic, the plaintiff, but also a lot of foreign companies understand and believe it is possible to obtain high amount of compensation through litigation cases in China. The second case is regarding the industrial production method and mood. And for this case, the most difficult part is how to preserve the evidence. As you know, there is no discovery procedure in China. The plaintiff have to submit all the evidence to prove the infringement they claimed. But the mood and the production method is only take place in the factory of the infringer. It is difficult, in fact, for the right holder to have such evidence. And for this case, we filed the invention patent infringement litigation and also apply the court to give some evidence preservation. That is to say, we request the court to the judges to enter the factory and investigate the factory and preserve the evidence. At last, we finally persuade the judge to believe there is a high possibility the infringement is constituted. And we also provide some information about where the mood is, where the factory is, and how to enter the factory and how to find the mood. And the judges finally accept our request and enter the factory of the infringer and take photos and take videos of the method and mood. So although in China, the burden of proof is very high and it is maybe difficult for the plaintiff to collect all the evidence, especially if the case is concerning the method, the mood, or some B2B products. But we have some procedures, for example, the evidence preservation by court. You can use such a procedure to have the evidence you want preserved and proceed the litigation smoothly. The third case is about trademark infringement. The plaintiff's trademark is Yakult and Yiliduo, the Chinese character. And the plaintiff's product is drink. It's very famous and popular in China. And the defendant is a company which manufacture and sells a product of bathroom, such as shower and the toilet. And in this case, we file trademark infringement litigation. And as you see, the plaintiff's product is drink and the defendant's product is bathroom product. The defendant claims that the product is not similar and it not constitute trademark infringement. And we claimed the plaintiff's trademark is well-known trademark in China, and the customers of drink and bathroom are all same, the common customers, the common users. And also the bathroom product will hurt the image of the drink. So we claimed our trademark shall be regarded as well-known trademark, and this case can have some cross-class protection. At last, the court supports our claim, and the court issued a first instance infringement about injunction and damages of more than 1 million Chinese yuan. Then this case is about trademark preemptive cases. The trademarks designed and used in products OEM manufactured in China by SoundAround, its American company. But it did not have this trademark registered in China in time. So another one. Still, a Chinese company knows the trademarks and have it registered in China. Also, it recorded it in the custom system. Then, SoundAround the American goods imported to USA. It is manufactured OEM in China and imported to USA, but the goods were detained several times by custom according to the application of Stone. And Stone claimed $200,000 to transfer the trademark. Obviously, Stone registered this trademark just for money. But the American company do not want to pay the money to such bad faith infringer. Then we advised such means. First, we submit evidence to custom to claim non-infringement. We claim such products are all OEM manufactured and all exported to American countries, and we have the trademark in American. We also filed a lawsuit claiming copyright infringement with court. We claimed such logo, the designed P constitutes work, and the trademark, the registration by Stone and use constitute copyright infringement. We also filed a dispute, cancellation, and invalidation against Stone's trademark. As a result, the goods detained by customer are released, and Stone's trademark registration cancelled and invalidated. Also, Stone are ordered to cease the copyright infringement and compensate 120,000 Chinese yuan. We have a very good ending. We cancelled the preemptive case trademarks, and the Americans, the real right holder, have the trademark back. For such trademark preemptive cases, our advice is, for foreign company, you shall register your trademarks in China as soon as possible. And if your trademarks are registered by others in advance, if you can collect some evidence to show you have the high popularity, you are well known, you are famous in China, over the world, you can provide such evidence. Or if your logo is designed, you can claim the copyright. And you can use such evidence and copyright to invalidate, to cancel the other's trademark registration. This case is regarding design imitation, but we cannot claim design patent. In this case, the plaintiff is AP, the famous the watch manufacturer, and the product is famous watch, Royal Oak. As the Royal Oak, the watch is issued since 1970s. It cannot have the valid design patent now. Then a lot of Chinese companies manufactured very similar watches. But we do not have the design patent, so we cannot claim the design patent infringement. In this case, we file unfair competition litigation, and we claimed the design of the watch is very unique, and the customers can judge the arranging of the manufacturer according to the design, the appearance of the watch. And because it is very famous and unique, the design can be protected as special decorates of well-known products, which are protected by anti-unfair competition law. At last, the judge supported our claim and determined the injunction and the damage of 1 million Chinese yuan. For such case, we would give some advice. First, the design patent is the most effective ways to protect the design, the appearance of the product. But in China, the protection period of design patent is only 10 years, and after the law is revised, the protection period is 15 years. And after the 15 years, how to protect the design? And if the product is very famous and the design is very unique, and for the customers, they can judge the resource of the product through the appearance, the design, then you can claim the unfair competition. To sum up, most of the imitating acts can be seized by related laws, the patent laws, the trademark laws, copyright laws, and unfair competition. And in China, injunction usually will be supported. Amount of damages grows higher and higher. Of course, it cannot be compared with American. Administrative means are more rapid, while litigation means are more effective. And it costs less to enforce IP rights in China than in US or in Europe. Foreign companies' IP rights can also be protected effectively. For example, the cases we just introduced, most of these cases are foreign companies' case. Okay, above are for your reference. If you are interested in any of the case, or if you have any problems concerning the IP infringement, please feel free to let us know. You may believe in China, the intellectual property rights situation is better and better, and our firm are experienced in dealing with all the kind of infringement cases. If you have any problems, just let us know. We will assist you.